Good morning, everybody. My name is Marty Mascari. I am a contractor under the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. We are thrilled once again to have our partners at Heyman Hogue for this webinar series. We've been doing it for 2.5 years now, I think, or something. And we sure are blessed to have you all. And so before we get started, first of all, today we're going to talk about, does a trust make sense in Texas? But we're going to go over the CEUs because some changes have been made, some significant changes we've made in CEUs for these webinars. And so we want to make sure we go over that. So if we can advance the slide one, there we go. Perfect. Okay, so this CEUs for today, the only CEUs we're offering for today is for licensed social workers and licensed professional counselors in the state of Texas. I do know that in one of the reminder emails that went out this morning that I caught that I didn't get fixed just in time, it said we were offering CLEs, and we're not. There's not CLEs, and there's not nursing anymore. It's just the two.
Yes, we are.
I'm sorry?
We did the CLE again. Yes, we did.
Oh, okay. So we are.
Yes.
I lied.
Just not
Sorry.
Nurses. Nurses is the only one. No.
Yeah, we're not doing nurses. Thank you. Okay, that's great.
If I'd
So
known
if
that,
you're
I
looking
would
for
have
CLEs,
advertised
there's
that.
CLEs. Okay, so today's webinar is worth 1.5 hours of CEU credits. You must complete the entire live webinar and Q&A in order to be eligible. And then you must complete the Google survey evaluation. It should give you it should ask if you want to go there as you close out of Zoom today to go. I think it asks if you want to take a survey, and that's the Google survey. But if it doesn't, please don't worry. I will also send that out in a follow-up email that will go out by the end of the day tomorrow. If you don't see it, give you the option as you close out of Zoom today. Please, we're going to give you a week to complete those, and then give us a good 4 weeks to get those certificates out to you. And I want to note, if you joined us last month, I was actually working this morning on this on a mail merge. I went to do the CEUs, but last month I didn't add the CEU question in to the survey, what certificates you were looking for until too late. So half of you completed the survey last month, but it didn't ask you what certificate you were looking for, because normally I didn't do that for these. And so I'm going to be sending you an email, or you can just email me and tell me that you were looking for a CEU or a certificate of attendance, and I'll go back and fill that in for you. So Sheila, I'm going to let you introduce Rex, if you would. So Sheila Williamson is with Heyman Hogue, and she'll introduce our speaker.
Yes. I am Sheila Williamson, the Director of Community Services from Heyman Hogue. Heyman Hogue is a faith-based law firm that does wills, trust, guardianship, probate, and Medicaid VA, or special needs. But what we love to do is educate. We educate everywhere we go, because in this case, a lot of you are professionals. And the cool thing about that is when we educate to you, then you can educate your clients, patients, whatever they may be. And an educated public is better for all of us. We are not here to sell you anything. We are here to educate you, which is why we have the long Q&A at the end, so that you get all your questions answered and you can be much more comfortable answering questions for your patients or clients. So like I said, the educated public is better for everyone. Now, joining us today, and this is his presentation anyway that he wrote, is Rex Hogue. Rex Hogue is the founding partner of Heyman Hogue. He has practiced for more than 25 years in this field. So he is known as a trust guru. This is the perfect presentation for him, because lawyers all over the country call him and ask him questions about trust. So There's nothing, my guess is, that you can ask him that he won't know. So without any further ado, my boss and my friend, Rex Hope.
Okay, does a trust make sense in Texas? And in the last just few weeks, I've heard several times how Texas has a very easy probate system. And I agree with that in terms of comparing our probate system to other states. But we're going to talk a little bit about today about what Texas probate is really like so that you can decide how easy it is. Now, we have some course objectives. So we want to compare trust to powers of attorney and guardianship for incapacity issues. We want to compare trust to other ways of passing assets upon death, including probate. We're going to compare trust to other estate planning tools for complex situations. We're going to talk about benefits that only trust can provide and the value of leaving assets in trust for beneficiaries. Now, I always start with what I call the administrative dragons. And here's the key point. How do you get a substitute signature when you cannot sign your own name? All estate planning, all estate administration revolves around that issue. And you will understand, I think, why I call this a dragon. And yes, that is a picture of a live dragon that I took. So dealing with incapacity, most people think of a power of attorney. In a power of attorney, a principal gives an agent a power of attorney. It is an invitation to third parties to let the agent act on the principal's behalf. And the agent only has the authority that a third party will recognize. Another way to deal with incapacity is guardianship. I call that the court-supervised management of assets for somebody who is legally incompetent. Some people call it living probate. We won't spend a lot of time on guardianship, but I have never had anybody who went through guardianship one time and then wanted to go through it again. And then the third way of dealing with it is a living trust. It can replace powers of attorney. It provides a necessary substitute signature so that you can avoid going to guardianship and probate. And it can provide instructions for the incapacitated trust maker's care. Now, how do we get to guardianship? Well, if a person owns assets in their own name, or two or more people own assets in their own names, and one becomes incapacitated, then we may have to go to probate court for a guardianship of the estate, which can be very difficult, or a guardianship of the person, which is easier. But I emphasize easier, not easy. Guardianship and probate are caused by the same problem. The problem is a person is unable to sign necessary documents to either manage or transfer their assets. Guardianship and probate solve that problem by having a judge authorize a substitute signature. But to get a judge to do that, you have to go to court. Guardianship and probate are and frequently the only solution to the problem. And I'll walk you through the basics of both of them today, and you can decide whether you think it's actually a good solution. I don't think it is the best solution. So our first case we're going to talk about today is Carl and Myra. They have three kids you might have heard of, Peter, Paul, and Mary. Myra is terminally ill. She can't manage assets for herself. She needs care pretty much most of the time. Carl has Alzheimer's. Their powers of attorney have failed. Now, that's all kind of in a vacuum. We need to know a little bit about the assets. So they have a $500,000 home, $500,000 IRA. They have $1.8 million in investment accounts managed in Carl's name and about $200,000 in joint bank accounts. So about a $3 million estate. Their old POAs are not valid. And by the way, Texas does change the law on POAs, and they made a significant change in 2017 that virtually invalidated most prior powers of attorney. Now, here's what they need. We need to get assets to provide for Carl and Myra. We need to sell the house because it's no longer feasible for them to live there. We need funds for Myra to be in a facility. Carl is better off in a facility. And just for the sake of this presentation, I'm going to say they started this about a year ago, but you're going to see some references where this was a case that took place a few years ago. So we need to get a doctor's report on Carl and Myra. We need to hire an attorney to file 2 different guardianship applications proposing their son Peter as the financial guardian. We've got to send notice to the interested parties. In this case, it's going to be each other and the kids. A judge appoints the same attorney ad litem for both cases. Now, that is a huge blessing. I've had cases where the judge did not appoint the same attorney ad litem, and so you're having to coordinate between 3 law firms. There's no access to financial info or assets except what they get from statements they found at the house, but they can't go access these assets. Well, the court investigator does a background check on Peter. Now, we originally covered this back when COVID was going on, and courts were so backlogged on background checks, it was taking months to get a background check. They don't have any access to financial information, but as I mentioned, they have statements from the house. Then Peter has to qualify for a bond. That bond is going to cost up to 3% of the assets subject to that guardianship. In this case, about $90,000. What if Peter can't qualify? What's going to happen? What if none of the 3 kids could qualify? Kids don't frequently have this kind of money laying around. Well, Peter's going to have to pay for that bond. He can be repaid in probate on down the road, but we don't know how long Carl and Myra are going to live because, like most of our clients, they won't tell us when they're going to die. Peter has to undergo approved training as a guardian, and that's a court-approved course that he'll have to go through and get a certificate from. Now, guardianship, I tell people it's one of those 12-step programs. I'm not going to go through all 12 steps, but the minimum cost of a high net worth guardianship in my, based on my observation, is $40,000 or more. And that's not counting the bond that Peter will have to get. And that's for each of them. This is going to be expensive. And it could get worse if there's creditors or predators hanging around out there. Let me tell you something most people don't know. Creditors and predators can attach their claims to a probate or a guardianship and have a 100% chance that their case will be heard in the probate court. If they file a claim in district court, their chances of seeing the light of day of the courtroom might be 1 to 5%, but it's 100% in guardianship or probate. The annual cost is likely to be a minimum of $10,000, but it's usually going to be more. And again, that's each. And it seems like there's a constant stream of surprises that goes on for as long as the ward is alive. And the ward is the person who the court has deemed to be incapacitated and for which the court appoints a guardian. Guardianship is disastrous for otherwise good estate, business, and asset protection planning. In fact, it's really not all that great for anyone else either. Guardianship leads to a lot of time. It takes months to get a guardianship in place. It costs a lot of money. You've got the cost for at least 2 lawyers, a doctor, and a social study, and all of that is going to come out of the estate. There's a lot of going to court. It usually takes multiple hearings with at least 2 lawyers and potentially here 3 lawyers if there was separate attorney ad litem for each of Carl and Myra. There's a complete loss of control. The family has no control over this process. It's very frustrating. It's one of the most frustrating things that families deal with in guardianship. There's also a loss of dignity. Nobody wants to go to court and say, my dad is incompetent. He can't do this. Going through the list of horribles that they may have to go through, talking about loss of bodily functions and stuff like that. And it's not a lot of fun if you're the potential ward up there hearing it either. So guardianship, time, money, going to court, control, and loss of dignity are the big issues. And these are major asset protection problems as well, because it opens the door for creditors and predators that would otherwise be shut. Well, Carl moved to the same facility as Myra a year ago. Now, even though in 2021 and 2022, it was possible to waive the required minimum distributions for Carl's IRA, Peter could not get the authority to do that in time. Again, we're moving them forward to back a year, but that's just one of the things that can come up due to lack of authority, and sometimes lack of authority to get those RMDs distributed before the end of the year so that there's not penalties for them. Back then, it created an unnecessary tax. Now, is the guardianship in place? Well, let's go back and look and again realize that if we've got personal assets or jointly held assets, that's the process we go through. Now let's compare it to what happens if we have a trust. Having a trust does not prevent incapacity, but it does change the rules. So first of all, the assets are managed by the terms of the trust. And in that sense, the trust replaces powers of attorney. You may remember a while ago, I said that powers of attorney are an agent only has the authority that a third party gives them. However, a trustee owns legal title to the assets. An institution cannot refuse to deal with a trustee. It avoids guardianship, at least for the assets that are in the trust or controlled by the trust. It can provide incapacity instructions. The successor trustee can manage it. They're easy to manage, change, and update, but they work best when the assets are fully aligned with the trust. Now, I'm going to share a little bit about incapacity instructions. This date is on the test at the end, so make sure y'all remember it. On August the 6th, 2013, my mother called my brother and I and told us that she wanted to move from Irving, where I grew up, down to San Antonio, where my brother lived, to be in an independent living facility. And then she's tacked on, and she wants to be there by the end of the month. No preparations had been made. Well, before I could even put the phone down on the desk from that 3-way call, my brother called me and started telling me that there's 1 million of those places in San Antonio. He's going to have to go find out what every single one of them offer, present that to mom, have her come down, look at the most promising ones. And this isn't going to happen by the end of the month. We'll be lucky if it happens by the end of the year. Well, I told my brother, you don't have to do that. In mom's trust, we have instructions about what facility features she would want if she had to go to a facility. So I sent him that checklist. He went on the internet, and in 20 minutes, he found 2 places within 10 minutes of his house that met all of mom's criteria. I then told my brother, now the pressure's on. You just got to pick the one of those that mom will be the least unhappy with. And she moved 23 days after that initial phone call. And again, no prior preparations had been made. That's the power of having a trust and having instructions in there to help take care of someone. Now, we're going to pretend like Carl and Myra did a trust 3 years ago, right after Myra was diagnosed, and see how this works out differently. Carl wasn't yet showing the signs of Alzheimer's. So here's how a typical, assuming they get the assets transferred to the trust, how is a typical trust going to work? Well, not all trusts are the same, but in this case, it worked well. Myra felt it best if Carl served with Mary. Carl preferred Peter to serve with him. Now, there's different reasons they might have chosen that, but they compromised and gave Carl a 40% vote to serve with all, Peter, Paul, and Mary, with a 20% vote each. When Mary needed a facility, the trust provided suitability instructions for her care. That made it a whole lot easier for the kids because nowadays you can do so much by the internet. It can speed up this process considerably. And they put Mary in a facility. I'm sorry, they put Myra in a facility that was close to Mary. And she had a little bit more time to deal with this, and she lived closer to them. Now, once Myra was in the facility, the kids took care of the bills. Carl didn't have to worry about it. He could spend his time with Myra. And Mary realized that Carl could not stay at home. And once they came to that conclusion, they realized they needed to declare him incapacitated. We have an incapacity panel in our trust. So that allows the three kids to say, hey, Dad is incapacitated by terms of this trust. That allows us to remove him as a trustee and take care of him instead of going to court to do it. They could remove Carl as a trustee as necessary, but in this case, it wasn't necessary because third parties are already used to dealing with the kids. And that's what my brother and I did for my mom. Even though Mom was capable of managing her assets, we were taking care of it. And 6 to 8 months after she moved to San Antonio, she became incompetent, but it didn't involve any changes in the trust. We just continued to handle things. They can move Carl to a facility without a doctor's statement, and the trust instructed them to use the same facility for both and even put them in the same room. Now, let me tell you, I review lots of trusts and I rarely see these kinds of instructions in trusts. But when it comes up in a situation like this, the family will be so grateful for those instructions. It also avoided unnecessary RMDs. Obviously, that was a few years ago. There's no fuss or issues with any third parties to handle things this way. It just was a very smooth process and way easier than a guardianship. So that kind of answers this question. What is the best way to deal with incapacity? Is it guardianship or a trust? Now, an update. Myra died 2 months ago. Let's see what trust administration without the trust and what the trust would be like, but using a different case. Now, in estate administration, everything goes through what I call the estate settlement cost funnel. Think of this as the days when you went to the grocery store and they scanned your item and put it in bags. Now I realize you do it yourself. Probate and trust administration and estate administration are not that way. There are 3 types of expenses that come out. 4 types. The first I call administrative. Notice that that is in green. That's because no matter what you do, you're going to have some administrative expenses. Now, when I look at this funnel, I ask three questions. Which administrative rules apply? How many different rules apply? And where do you put your family in this process? The second type of expense is probate. And then the third type of expense is creditors or predators. And the fourth expense is taxes. Now, those three are in red. They're in red because it is possible to plan around those issues. Again, you can't completely avoid administrative issues, but you can make them much easier. Now, think of those little spigots on the top. Water comes out of the funnel. Water represents the assets in the estate. But then once those spigots get turned off, whatever's left goes to the family. By the way, if you have to file a Form 706, which is the estate tax return, just be aware that the administrative costs are going to increase and it's going to take a lot longer. And we're in a situation and have been for several years now where we have voluntary 706s being filed. Used to be that we only filed them if we absolutely had to, but just due to the rules, it makes a lot of sense to file them when they're not required, because of some benefits that haven't always been available. Now, there are 4 or 5 ways that assets pass on death. As you're going to see, there's 2 of them in one box. These are in the order that they go. So the very first thing we look at were assets owned jointly with right of survivorship. If so, it passes to one or more individual survivors. If it doesn't pass that way, we ask, is there a beneficiary designation or a TOD, or a transfer on death designation? I call that planning by the box because there's a box on a form that says, if something happens to you, where do you want the assets to go? If you choose an individual, then you are now playing by the same rules as you are with right of survivorship. It's not the same from top down to here, but it's the same once you get here. Now, that looks very simple. All 3 of those look simple, but they're not. As a matter of fact, I'm going to show you how you can lose complete control over the assets and how these will blow any tax planning you may have done. Now, if assets don't pass by beneficiary designation and TOD, our next question is it owned by a trust? If so, it passes according to the terms of that trust. Now, if it isn't owned by the trust, there's only one thing left. It's owned individually, it goes through probate, and it's controlled by the will or intestate succession. Intestate succession, in case you don't know, is the will our state legislature has graciously provided for you if you don't do a will or if your will is not valid. Now let's go back to the box. You can, in the box, appoint the trust, and that will allow the trust instructions to control the distribution. If everything goes wrong with the box, or you can name the probate estate, I see that from time to time, but probate is really what happens when the box completely fails. And then if we have probate, we can use a pour over will to transfer the assets to the trust so that the trust instructions do still control. You do still have to go through probate though. Now, all 4 of these get assets to beneficiaries, but they're not equal. So let's look at the administrative rules. Now, before we get to those administrative rules, you always have to consider case law, the banking regulations, the Internal Revenue Code, and the Treasury regulations. Now, joint with right of survivorship and beneficiary designations and TODs all have one common set of rules. The first thing you should notice is that there are special bad tax rules that apply under the Internal Revenue Code. Then in each state where you have owners, survivors, beneficiaries, or where assets are located, you may have multiple laws that come into play. The estates or probate code, the property code, the insurance code, or the family code. And I'm going to show you a case where we had several of those. If it's owned by a trust, we have the Texas Trust Code. That is going to allow the very fastest access to assets, regardless of the other ways one might pass the assets. Then if it's owned by an individual, in each state where we have a real property interest, we're going to go through probate, and you're going to deal with that state's estate, so probate code, the property code, and possibly other laws, depending on the situation. Now, a real property interest is not the same in every state. For example, in Texas, mineral interests are property interests, real property interests. But in some states, they're personal property interests and don't necessarily go through probate. Now, the overuse of right of survivorship and beneficiary designations is something that I see all the time. And I am going to go through a case here where we're going to look at these administrative rules, but I've given you these rules so that you'll kind of understand why this case worked out the way it did. Merlene had 3 children, Harry, Don, and Norma. She died on a Sunday. 8 days later, Norma came to us on Monday to probate Mom's will, and she was in a hurry. This lady was highly motivated. When she left our office Monday, I gave her a 23-page package and said, if you'll fill this out and get it back to us, we will have it ready to file with the courts within 48 hours. To my complete surprise, when we arrived the next morning, Norma was waiting at our door, and she had that package all filled out. Now, this is what I noticed. 50% of the assets passed by right of survivorship, POD, and POD. 30% passed by beneficiary designation. 20% passed through her will, and she's got a home here and a home in Wisconsin. Both of her sons are in second marriages. Now, Norma lives here. She's going to handle the probate. She's in her first marriage. She's got kids, no issues. And the reason she was so hot to get this done is because the Texas real estate market was going crazy. And this case actually came in about the same time that I was selling my mom's house from her moving to San Antonio. And just to give you an idea of what was going on, I talked to the realtor a little after 5 o'clock on Thursday. We put it on the market. And on Monday, a little after 5 o'clock, the realtor called me and he said, Mr. Hogue, I have some bad news for you. We only have 7 offers on your house, and only 6 of them are above your asking price. So I asked him to keep that kind of bad news coming. 4 days, 7 offers. That was how hot the real estate market was. Well, she can't sell the Texas real estate until after the Texas probate. And that doesn't mean that we have to be completely through probate, but we at least have to get the will probated and admitted as valid so that she can exercise her authority. She can't sell the Wisconsin real estate until after the Texas probate and then the Wisconsin probate. 80% of her 1/3 is going to go outright to her within a month, but without any protection. And I'm going to show you the significance of that. Harry, he lived in Illinois, second marriage, had minor kids from prior to the marriage. Now, one of the questions I asked her when she came in is, how did her mom like her 2 new daughters-in-law? I did not know whether that would be relevant, but it turned out to be very relevant here. Because Harry died 10 days after his mom. And by the way, Norma's answer was her mom didn't like either one of them. She liked the first one better. Well, again, Norma comes to us on Monday. On Tuesday, she brought us the package and we told her, be ready to come by here and sign. And we'll get it to the court before the deadline. But Thursday morning when we called, we couldn't reach her. And here's the reason why. Now, Harry's 80% of his 1/3, pay attention to this, folks, right of survivorship vests in 5 days in both Illinois and Texas. That means that now is going to pass according to Harry's estate plan, not Merlene's estate plan. Beneficiary designations and TOD vest immediately. Those are also going to vest and pass by Harry's estate plan. Harry has a simple will with his new wife, meaning everything goes to her. What about his minor kids? Well, they're left out of 80% of the assets. Now, the 20% coming from the will required that he outlive her by 30 days. He did not. Therefore, he is going to be treated in the will as though he predeceased her. As a result, those assets will ultimately go to his minor children. However, they are going to have to go through a guardianship in Illinois. Now, they probably would have had to anyway, but folks, Merlene lost control of 100% of what was going to Harry. 80% is going to somebody she didn't want. The other 20% will not be available to her grandkids until they turn 18. Now, we did not reach Norma on Thursday, and it was very frustrating because we went to a lot of trouble to get those documents ready in 48 hours. So here's Don's story. He's in Wisconsin, second marriage, has kids from part of the marriage, but at least his are adult kids. Half of his 1/3 is from right of survivorship, TOD, and POD. The bank tells him that those have paid. He needs to open a new account. Now, I forgot to tell you that when Norma came in, she told us she had just dropped Don and his family off for them to fly back to Wisconsin. So Monday afternoon, he's got a message from the bank and they tell him he needs to come in and open a new account. And he tells them, I'll be over there tomorrow to do it. So the next morning, he received divorce papers from his wife before he left the house. A process server showed up to deliver that lawsuit to him. And now he needs an attorney. So he spends the day finding an attorney. Wednesday, Harry dies, and Don realizes that, wow, he now needs to make an emergency trip to Illinois. So he put the inheritance into a joint account with his wife, who's suing him for divorce, and goes to the funeral. I was shocked until I thought about it. Mom died. 9 days later, he finds out he's going through divorce. Day 10, he finds out his brother dies. He's got his second funeral to go to. He was in a fog. That's why he did this. Now, under the Wisconsin Family Code, his wife is now entitled to 1/3 of it. Merlene loses control of 1/6 of what is going to Don. Do you see how right of survivorship, beneficiary designations, and TODs cause loss of control. It's when things go wrong in the lives of other people that you're planning to leave stuff to. And these are not the only things that can go wrong, by the way. Now, probate technically means to prove up the will. I prefer the layman's definition, though. The court supervised transfer of assets for someone who has died. Now, people ask us two questions about probate. How much does it cost, and how long does it take? No one can honestly answer those questions. If you call a law firm and ask those questions and they give you an answer, run away, because they'll lie to you about other things too. Here's what you should ask if you knew to. Who gets paid first and who controls the process? So under the Texas Estates Code, here's the order of payments. Funeral and last illness up to $15,000 each if the court approves. Courts approve things, the lawyers go into court to argue them. It is not the most efficient way to do something. Family allowance for up to 1 year if there are qualifying family members, meaning surviving spouse, minor children, or incapacitated adult children. Then comes the cost of administration, attorneys, court costs, executor, preserving, safekeeping, and managing the estate, and unpaid guardianship. Now, I have a high school friend who's a funeral director, and we were talking about this one time, and he was bragging about, hey, see, we got more power in the legislature than y'all do. And I told him, my friend, you have been deceived. We do not have to take a case until we've been paid. So regardless of what the statute says, we get paid first, not y'all. Don't want to ruin your day though. So anyway, secured claims and tax liens, unpaid child support and interest that won't apply in every case, of course. Taxes, penalties, and interest. Wow, I hear y'all cheering. Y'all realize that's the IRS, number 6 on the list in Texas. Then the cost of confinement if a person was in jail or prison. Repayment of medical assistance if they were on Medicaid. And then finally, other claims, generally unsecured. And I'm going to talk a little bit about rental owner problems that can come up. We had a case where somebody had rented a house. She owned the house. I think she owned 70% of it with her 3 kids, but the lease agreement was that they would pay her. Unfortunately, she died during the renter's 2nd month there. So the 3rd month, the renter, who had some knowledge, said, hey, I can't pay y'all. I can only pay the estate. Well, just due to numerous complications, it was a year before they could get the will probated and get somebody appointed. So for a year, he just put the money in a savings account, and the kids had to pay for repairs, insurance, taxes, anything that came up, and no money in the interim. And then at the end of the year, he wanted to renew the lease. Well, and that happened about the time that they got the will probated, and he gave him a check for all of it. Now, who is not on the list? Look and see, and you won't see the family and loved ones. They are last on the list. They don't get anything until these other people have been taken care of. Now, it's great to know the order, but who controls this process? Well, it's not the courts, and it's not the attorneys. It's people making claims. Nobody knows how many claims might be made. Nobody knows what it will cost to address each claim. Nobody knows how long it will take to resolve each claim. That's why nobody who's being honest can tell you how long probate will take and what it will cost. Now, this is my definition of probate. Every time I've given this to a probate judge, I've gotten one of two answers or responses. But first, my definition. It's a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit creditors. Judges have said to me either that's exactly right or you're not wrong. I've yet to have them tell me that's wrong. Now, for Merlene's situation, she had two probates, the Texas home and the Wisconsin property. The non-liquid assets, the home and property, some of those were covered by probate. Somebody's going to have to put up their money for probate and be paid back from the sales of assets. Someone's going to have to maintain the properties until sold. And keep in mind, 80% of this, the cash stuff was paid out. So those pieces of real estate are not generating any income. Now, if it turns out that the husband's name is still on deeds, additional probates are going to be necessary in each state where his name is on the real property. However, that was not an issue here, but I have seen it come up. Then 1/3 went to each child. Each case is different, and you can see 3 children here, 3 completely different results. Norma's 1/3 worked fine, but it wasn't simple. All she got was the assets, no other benefits. Had to front the cost for probates in both states. Harry's estate couldn't assist because of his death. Don couldn't assist because of his divorce. Norma could only be paid back on the sale of the properties. It could have been a lot worse, but it could have been a whole lot easier too. Harry's 1/3, 80% went to his new wife, who Merlene never liked. 20% will go through probate in Texas and Wisconsin. 20% will go to the minor children. When they turn 18, they'll get it. And guess what? That's a nice recipe for them getting a very nice car, but no college education. Grandchildren will go through a guardianship to get non-liquid real estate assets. Each grandchild will get his or her share at 18 or 21 without any other benefits, depending on state law. Merlene lost complete control of this share. It was a complete disaster. Don's 1/3, his soon-to-be ex, is going to get 1/6 of what went to him. The remainder comes to him with no other benefits. Overall for Don, poor, but not the complete disaster of Harry's. Now, what would have happened if Merlene had a trust instead? Well, there would have been 0 probates regarding anything related to her estate. It would have been faster and less expensive sale on both properties. 0 guardianships for minor children. 100% of the benefits after relatively low costs would have gone to those who Merlene wanted to see benefit from her estate. Norma's 1/3 part came from the sale of real estate. All would have been protected against a future divorce. Does this family have to worry about divorce? 2 out of 3 kids have already been through one. All would have been protected from any existing creditors. All would have been protected from future lawsuits. Now, by the way, not every trust will do this. I'm going to show you the kind of tool we use that allows you to do this kind of planning. Harry's 1/3, 100% of the benefit would have gone to Harry's minor children. His wife wouldn't have gotten anything. There would have been no guardianship. It would have been controlled by the trustee until the grandchildren are much older, and it could have provided for their college education and their medical expenses. And then once they got control of it, it would have been protected against their future divorces, future creditors, and future predators. Don's 1/3, 100% would have benefited Don. His soon-to-be ex would get 0, the favorite amount for an ex. He would be protected against a future divorce if he got remarried. everything would have been protected from his existing creditors, and all would have been protected from a future lawsuit. Now, I talk about existing creditors, and I have people say, well, I want my kids to pay their creditors. I know a lady who about 2.5 years ago, she broke her leg when she fell off a step stool, was in the hospital for 12 days, ran up a $325,000 hospital bill. That doesn't count doctors. And it doesn't count surgeries, and it doesn't count rehab. After going through that twice, about 2.5 months ago, she slept and fell in her backyard, and it started raining. It took 45 minutes for them to get her. She broke the same leg. Now, I have no idea what that cost is going to be, but if I were her parents, I would want what I leave her to go for her benefit, not to pay medical bills. Because medical bills, they might get her out of debt, but they won't help her with other things she might need. So you need to think about that. Now, what is a trust? It's a contract that involves three parties. Trust maker, go by other names, they make up the rules of the game. The trustee controls the trust. They manage the assets, and specifically, they manage the assets according to the rules the trust maker set up for the benefit of the beneficiary. In our typical living trust, the trust maker serves in all three roles as long as they can. They hold assets for the trust, and that's often stated as the trust owns the assets. That's not technically correct, but that's how most people think of it. Assets in the trust avoid guardianship and probate. Now, while you're alive, they avoid guardianship for assets in the trust. They can provide instructions for care in case of incapacity. They give you a chance to see how successor trustees do managing assets. And I see some people occasionally using this strategy. You know, I think my kids are good. They've graduated from college, but how are they really going to do? And they can give them a chance to see how they would do. Easy to manage change and updates, but you need to get the assets fully aligned with the trust while you're alive. And what do we mean by the assets fully aligned? Well, we mean that the assets are owned by the trust. Bank accounts have been transferred in the trust name. The trust owns life insurance policies. The trust is a beneficiary of life insurance policies. All that sort of stuff needs to be done. After death, assets owned by or controlled by the trust to avoid probate, provides distribution instructions for all the assets. Again, faster access to assets. Faster and easier to administer. Folks, we have done over 1,000 probates. We have done hundreds of trust administrations. And I will tell you this, I have yet to see a case where trust administration costs were more than probate. They're always less. They're always faster than a comparable probate. And notice I did not say that trust administration is simple. None of it's simple, but it's simpler than any of these other tools with fewer disadvantages. It also involves only one state's law. Right of survivorship, beneficiary designations, TODs can involve multiple state laws depending on where your child lives. And it provides more certainty of results than other distribution rules. And we saw that in the case with Merlene. Now, for married couples, there's some non-tax reasons for doing AB planning. A lot of people think an AB plan is only for tax purposes. Well, they are not. Look at these reasons. They offer flexibility for future changes. Do changes happen? Of course they do. Your family situation is going to change. Your financial situation is going to change. You need a plan that can change with you. Each spouse controls the distribution of their share. Here's a question I always ask married couples. If you died first and your spouse got remarried, do you want your assets to go to your children, or do you want it to go to your replacement? In over, well, about 31 years of practicing law, guess what answer I have never heard? I have never had them say, oh, my replacement would be fine. No, it's not fine. That's a reason for doing an AB plan. In fact, it's even, I think, the biggest and most important reason. You can help maintain government benefits for the survivor. You can provide asset protection for the surviving spouse. That B share, we only do B shares that are asset protected. There's over 28,000 ways to do them. We eliminate all the ones that don't provide asset protection for the surviving spouse in case they get sued. It prevents accidentally disinheriting children. It can reduce friction in second marriages. Now, folks, these are non-tax reasons for doing an AB plan. And for most people, these are more important than the tax benefits. So how does an AB work? Well, the A side, that's the survivor share. The survivor controls it completely. The A actually stands for the above ground spouse. You're not going to believe what B stands for. Okay, yeah, you're right. It's the below ground spouse. That's the deceased spouse's share. Now, typically, the surviving spouse is the beneficiary or one of the beneficiaries. But upon the survivor's death, the decedent's kids receive it. It can use all or part of the first exemption. And again, it provides asset protection for the survivor. Now, I am bypassing a lot of things about AB planning, but ultimately you can pass 2 exemptions estate tax free. And right now, the exemption this year is $13.61 million per person. So you may think, well, I don't have to worry about tax planning. Don't count on it. The law is going to change in 2026. Now, on the surviving spouse's death, trusts make dealing with difficult family members much easier. So one thing is protecting kids from each other. Sorry, lost control for a minute there. Don't know why. Here's an example of a case I handled. Dad died, he had 4 daughters. Okay. 3 of the daughters were responsible and they got along well. But then we had number 4, Suzanne. Suzanne, right after Dad died, went over to the house and she took out of the house all the gifts that Daddy had given her. However, Suzanne didn't have any proof that Daddy had given those gifts. So Suzanne also made some demands. She wanted a copy of the trust. She wanted a copy of the real estate sale contract when they sold it, and copies of bank statements. Now, those 3 things she's entitled to by law, but her 3 responsible sisters didn't want to give it to her. They were mad at her for the gifts, but we handled the gifts by explaining to Suzanne, here's the deal. You can take those gifts as your share. You won't get anything else, or you can get 1/4 of the other goodies that are worth a whole lot more. She had everything back to the house within 24 hours. But I also had to explain to her siblings, y'all have to provide her this stuff by law. She's entitled. And I realized that this was a 3 against 1 situation. You're never going to make those 4 girls happy. But this is what I had to say to the three responsible daughters. If she sues, this is going to be decided by a jury. If you did not provide her what the law requires, how's the jury going to see that? They're going to find in your sister's favor despite what she's done, because you did not comply with the law, you breached your fiduciary duty, you breached the terms of the trust, you're going to lose. But thank heaven we had a trust that made things a whole lot easier than it would have been without it. Now, John and Jane had 5 kids. They had 2 older responsible sons. And then they had this guy, proud to call himself the black sheep of the family. He was the middle son. Then they had 2 inexperienced children who were younger. And John was the last one to die, and he wanted to make sure that his 2 responsible sons would manage everything. Well, at our initial meeting, Black Sheep informed us that he had an attorney and he intended to contest the trust. We asked him if his attorney was going to be at the meeting, and he informed us no, he didn't need him there. So we informed him, unfortunately, since you're represented by counsel, we can't answer your questions. We can only talk to your attorney. Well, he finally stopped the meeting, and we reconvened that afternoon when he could get his attorney there. And he had to go hire an attorney. We suspected he didn't have one, but he wasn't going to be in control of this. So sorry. When the attorney showed up, we gave him what's called the interim clause of the trust. It said, your client's already informed us that y'all intend to contest this. We thought you'd like to know what you're up against. Well, when the meeting broke up, about 15 minutes after leaving, we got a call from the other attorney to tell us we will not be contesting the trust. Now, his office was about 15 minutes from our office. So I pretty much knew how quickly that conversation took place. Then I got a call from my clients. One of the brothers called me and said, Black Sheep called him at 3 in the morning, been his ear for 45 minutes, complained, moaned, groaned, carried on. And he told me he has a job. He can't be answering phone calls in the middle of the night. So I said, I know how to fix that. So at our next meeting, I told the 2 responsible sons, I'm going to appear to lecture you about your duties. Know that these comments are not directed at you. They're directed directly at Black Sheep. And this is what I told them. Y'all owe a fiduciary duty to your siblings. Your duty is to manage this trust the way that the trust calls for. But y'all are a family. If you being the trustee interferes with family relationships, resign and let a bank do it. Banks are not open on the weekend. They're not open at 3 o'clock in the morning for phone calls, just to pull an example out of the air. Well, 15 minutes after leaving that meeting, the attorney called. He apologized for the 3 a.m. phone call and promised there would not be any more of them. And I'm kind of thinking that he must have told his client, these people have you hogtied over a barrel. And by the way, we informed him that the expenses that Black Sheep is running up are going to be coming out of his share. So tell him to keep it up. We're expensed by the hour, and there were 2 of us attorneys working on it. Black Sheep conceded. Now, another case was the case of brother and sister, Johnny and Jenny. Now, Johnny lived with mom to take care of her. When mom died, he decided to live there rent-free using mom's funds for his own expenses. However, the trust prohibits that. It requires him to pay rent, pay back expenses since mom no longer needs them, and gives Jenny easy leverage to make things right. Now, John was complaining, hey, I got to live here. I'm here to take care of things. I need electricity. Yes, you do, but your mother doesn't. So if you need electricity, you pay for it. And you're going to have to pay rent just like you would anywhere else. Sadly, I've seen this kind of situation come up multiple times. Now, here's some reasons that you need to leave things in trust for the children. Predator dragons. Now, I'm going to define asset protection as protecting and preserving assets from unnecessary loss. Those predator dragons, I think I've got a picture of one I'll show you. I'll see if I remember to put it in here. Anyway, the biggest risk to your estate plan is your child's spouse's divorce lawyer. That comes as quite a surprise to many people. Let me tell you, family lawyers are great at disrupting the estate plans when their clients are going through divorce with somebody who's inheriting property or who has inherited property. Beneficiary debts, extraordinary bills like medical bills, like I talked about my friend who's had extraordinary medical bills. Predator threats, future lawsuits. Does a beneficiary have a high-risk job? Does a beneficiary live in a state that provides no asset protection? I'm going to give you a couple of examples of that. What state does the beneficiary live in? I always want to know this, and I always want to know what their spouses do for a living, them and their spouses. And then how would the loss of those inherited assets affect your beneficiaries? Well, and this is true not just of issues related around estates, it's really any lawsuits. People think, man, that lawsuit just came out of nowhere. That dragon just flew down and snatched stuff. Well, let me tell you, there's no such thing as a dragon that comes out of nowhere. If you knew what to look for, you would know where to look for dragons coming. Now, let's look at ways to pass to your beneficiary. You can pass it outright. There's no protection for beneficiaries from lawsuits, guardianship if they become incapacitated, or probate upon their death. Is that a good way to do it? I don't think so. Then there's a convenience trust. It provides limited protection. It does maintain it as separate property, and it does provide protection against guardianship and probate, and even estate tax. It can possibly protect a child from their own bad money management. Now, there's a combination of these two called a payout trust that I'm not going to take time to show you, but the other option is a heritage trust, and it offers full protection. It protects, it does everything the convenience trust does, plus protects from creditors and lawsuit predators, bad marriages, first death in marriage, loss of government benefits. And then it goes into a dynasty trust so that it can go on for generations. Carrie was a young lady who inherited $3 million from her parents. Unfortunately, she was just shortly thereafter involved in a car accident in Massachusetts. What happened in the accident is some guy tried to go around her at an intersection, flipped her bumper, caused her to veer off. She T-boned a van load of daycare kids, and it killed the driver and 2 of the kids. Carrie was not seriously hurt. But as you might have guessed, there was a lawsuit after the accident. The jury, the case went to trial. The jury came back with a $9.8 million judgment. They found the guy who hit Carrie to be 90% responsible, but they found Carrie to be 10% responsible. I wasn't there. I don't know why they decided that. I just know the outcome. How much does Carrie have to pay? Most people think, well, she has to pay 10% of it. That's $980,000. That's sad, but it's not everything. Except that's wrong. Massachusetts is what is called a pure joint and several liability state. That means that if you are 1% liable, you can pay 100% of the claim. Carrie lost her entire inheritance because of that accident. Now, it didn't have to be that way. Compare that to another Massachusetts case, and that's the night that Ted got a little bit too much elbow exercise, and he failed to negotiate the bridge over the Chappaquiddick River. That took place in 1969. Sadly, Mary Jo Kopechne died. Now, Ted Kennedy was 100% at fault. However, his parents had left him the assets in what we call a heritage trust. The Kopechne family could not touch those assets. But we saw that heritage trust show up 2 more times in Ted Kennedy's life. In 1982, he went through a divorce with his wife, Joan. Joan shouldn't have been surprised to learn that all the assets in there were his separate property and she couldn't attach them, but she may have been shocked to learn that all those assets in there couldn't count against him in the divorce. The judge had to treat it as though he was penniless, except for what the 2 of them owned. Then Ted Kennedy got remarried to a lady named Vicky, and when he died, Vicky found like Jackie Kennedy and Ethel Kennedy before her, because her name did not start out in life as Kennedy, she wasn't entitled to anything in that trust. So that's 3 examples in one case of how the Heritage Trust works. Now, a lot of people will look at these 2 cases and goes, yeah, but they had millions of dollars. Well, let me tell you, my experience with kids is that when they're getting as much as $200,000 to $400,000 each, they absolutely want the Heritage Trust. Why? They recognize that life's uncertain, and what they inherit, they don't want to see lost. And I have parents who tell me, I don't want to control my kids from the grave. Okay, you can give them a significant amount of control, but how about protecting them from the grave? That's the way to think of this. Compare or look at this case. Ron inherited $600,000. That included a $300,000 IRA. His wife, Amy, was going to med school. He only took RMDs from the IRAs, and he invested well. He used the non-IRA to pay her debts, her school, and bought them a home with the non-IRA $300,000. Then Amy filed for divorce. By that time, the IRA was $600,000, and by the way, this happened under the old rules, not the new rules that I'm not really going to talk about today. But look what happened. Amy got $300,000 of the IRA and the house. Mind you, that was inherited property. You look at this case, do you understand why I say your child's spouse's divorce lawyer is the biggest threat to your plan? That could have been avoided. Then consider the case of Angie and Jack. They had a couple of young children. Her mother left her $400,000. But Jack said to her, hey, honey, if you really love me, let me use this money for a business. And he bought a business. Now, there was some initial success, but then the company got sued. And the result of that is they went through a business bankruptcy. They still owe the business loan. So they still owe, he took the 400,000, put it down on the business and got a loan for the other 400,000. They had to go through personal bankruptcy. They went through a divorce. Ultimately got remarried, but guess what? Angie now has nothing but the 2 kids. $400,000, especially at her age, could have provided her retirement. You know, her mother could have protected her from this, but she did not. Now, that's some reasons that hopefully we've shown you that we've met the objectives today. We've shown you how trusts compare to these other tools, how they work. Let me tell you a little bit about how we plan. We analyze your family situation, your financial situation, and we help figure out what are your goals and objectives. Then we analyze the specific planning tools considering your family situation, your financial situation, and your specific goals and objectives. Now, I've seen that somebody asked a question, what do trusts cost? There is not a single answer to that. We have 10 different trust-based plans for married couples, all with different fees. We have 5 different fee structures for single people with trust, depending on these particular situations. You have to consider, what are you trying to protect? Who are you trying to protect it from? And what tools are going to work in your case? So I occasionally have somebody come in and they want to do a lot of complicated things. And they heard that somebody did a trust for $1,500, but their case is way too complicated for that. That's, you know, we can educate people and tell them this is what you need to spend to accomplish your goals and objectives. Now, if you don't want to spend that much, we have lesser plans, but they don't do as much. So the real question is, are they going to do what you need? Every case is different. But before planning, you're holding your bag of money out there. Dragons are going to come. And just remember, it doesn't matter which one, but one's going to come along and snatch that money out of your hands eventually. However, our goal is we want to build you defenses, put you behind a castle. Now, is that going to keep the dragons from coming? No. It's just that they can't get into the castle, and now you have a knight to fight off the dragons. And yes, pictures of real live dragons there. The knight, I don't know about him anyway. But anyway, folks, at this point, let's take questions.
And there are several. But first, I want to remind everyone that this is not selling you anything. What we're aiming to do, he was answering a question as to what a trust costs, because the person asking the question said that several of her clients are asking. And so it can be all over the board. And he was just trying to explain to you that any attorney that just tells you that it's a certain price without even hearing your situation, that's not right. You might as well be getting that off the internet. It's not the same thing. So you need to go to someone that specializes in what they do, and then they can do you a good job. So that's what he was answering, in case there were any question about that, because we're not selling this. Okay, now on to the questions. Okay, the first question Arma asks, can you kindly give an example of suitability instructions for her care? Is it a list of what her medical needs are? Is it a list of nursing homes? Do nursing homes have a list of services they provide to help facilitate this process? Well, yes and no. I can answer that because of the networking that I do. But Tracy has provided you with how you can check up on a nursing home and see what all they do. But Rex, would you please answer the question, an example of suitability instructions for her care? I don't know what.
Yeah, for example, they may want to be in a facility that offers activities that they want to participate in. They may want to be in a facility that is close to a loved one if they have to go to a facility. In the case of a husband and wife, they may want to be in the same room. In fact, they most likely want to be in the same room. So what we've done, and I've worked with colleagues for 30 years, developing instructions that we put in our trust to take care of people who might become incapacitated. And I'm very fortunate that I've been a part of 2 organizations where attorneys get together, we share information back and forth, and I've got some really bright colleagues out there. I'm always honored to share information with them and learn from them because nobody knows it all. But there's a lot of ways that those instructions come up. And we have a tool in our office that goes above and beyond just instructions in the trust. And I'm just going to, for a married couple, on average, we have about 18 pages of instructions for how to take care of somebody who's incapacitated. But we have another document that we call our personal and healthcare instructions that's about 22 pages long of things that we took out of the trust because we found they changed over time. And rather than having to update the trust, we could just give you a new form for you to fill out. And you can say, if I were in situation A, I want number 1. If I were in situation B, I want number 2. And you know what? These things are not topics that come up at the dinner table. So your family loves having those instructions. And I have dealt with plenty of people who they've got no instructions to work with, just take care of mom. Oh my goodness, what does that mean? So.
Okay, the next question is from Shantani. How is a will determined to be invalid?
So when you go to court to prove up the will, the question for the court, and I think most courts look to say, yes, we want this will to be valid so this estate can be administered as easily as possible, because when there's no will, it's a lot more difficult. But there can be things that make a will invalid. For example, not being properly executed, not having a notary signature. Now you might be able to prove that will up by other means, or if you don't have, I'm going to call them neutral witnesses, i.e. not your family members. It takes about half a page to fill out, or maybe a third of the page to fill out for the bar exam. What are the requirements of a valid will? And I remember that because that was on the bar exam the year I took it. And I was already practicing in this area of law, and I thought, boy, that was a gimme for me. But there's a lot of requirements in the law about what makes a valid will. So as long as those requirements look like they've been met, the court is typically going to accept the will as valid.
Next question. Maria asked, would it be possible for you to elaborate between the differences between a ladybird and the living trust? And I did say to her that a ladybird is a deed, but I think she means using that as opposed to, yeah.
I am not a big fan of the ladybird deed because things can go wrong. It's effectively sort of like right of survivorship or a beneficiary designation. And you may have a ladybird deed. And let's just go back to Norma's situation with her mother, Merlene. Let's say that a ladybird deed had been done to those 3 kids. Her brother dies. And now suddenly we've got another probate to deal with, and we did that ladybird deed to avoid probate. That's a problem with ladybird deeds. Having the trust own the deed, that's what we've done. I've done it for over 30 years. I have never ultimately had a problem with that.
Okay. All right. Nancy asked, what if there is no family member or trusted associate who can be named as a trustee?
Well, there's some great commercial trust companies out there that can always serve. A trust never fails because of the failure of a named trustee to serve. We can always get another trustee. So there's people out there that can do it, and we work with some of those companies. And I think right now there are more choices for good commercial trustees out there than in my entire career. We have more that we've worked with recently that are good than ever before.
Olga, real quick, Olga, in the question about appointments, if you could address that directly to Sheila or Rex after the fact, that would be great. And I'll include our contact information in the follow-up email.